The Prisoners Rehabilitation and Welfare Act, PRAWA, has called on the federal government to erect more structures in correctional centers across the country to ease congestion in the facilities. The executive director of the group, Uju Agomoh, made this call during a strategic engagement with the press in Abuja to emphasize the need for both state and federal administration to construct additional facilities to accommodate more inmates at custodial centers. Furthermore, she urged the government to take steps to improve the welfare of correctional officers, aiming to enhance their commitment and efficiency in discharging their duties.
On the issue of sustainable strategies for reducing high number of pretrial detainees in custodial centers, we encourage full implementation of Section 12, subsection 4 to 12 of the Nigerian Correctional Service Act of 2019. We recommend having a strong synergy between the arresting bodies and prosecuting agencies, encourage the provision of pro bono services, and improved access to pretrial detainees in the custodial centers by agencies statutorily mandated to provide free legal services as well as civil society organizations. We strongly recommend the need to enhance synergy between the Legal Aid Council of Nigeria, the National Human Rights Commission of Nigeria, and non-governmental organizations. We strongly recommend that there is need to situate court within or close to the custodial centers to take care of pretrial detainees. We strongly encourage the full implementation of the Administration of Criminal Justice Act and the Administration of Criminal Justice laws for the states that have domesticated same, and indeed the domestication of the Administration of Criminal Justice Act by those states that are yet to domesticate this. We urge governments, both at the state and federal levels, to build more structures to accommodate inmates of custodial centers in humane processes. And this, of course, may include renovation of existing structures to bring them to international standards. We recommend that the legislature hastens amendment of the criminal laws and the decriminalization and declassification of minor and petty offenses in Nigerian laws. We strongly recommend the need to strengthen the use of virtual courts and for these to be widely applied across the various jurisdictions in state jurisdictions in the country. We urge the government to provide adequate logistics to enable transportation of inmates to court. We also likewise urge the government to ensure training and retraining of police and other law enforcement agencies with the mandate to arrest and detain, as well as training for courts and correctional service personnel. We urge the government to take steps to ensure funding and budget allocation to stakeholders in the administration of criminal justice, especially the Legal Aid Council of Nigeria and other organizations in that sector. Strongly recommend the development and implementation of diversionary programs as provided for in the Administration of Criminal Justice Act and Criminal Justice Law, Child Rights Act, and the Nigerian Correctional Service Act.
When you look at the principal laws we had in place, Criminal Procedure Act and Criminal Procedure Code, the essence of this act was to govern and regulate our criminal proceedings. However, experts discovered that there are so many areas, so many gaps that need to be looked into and to have a breach. And that is why the committee came up with the Administration of Criminal Justice Committee to look into those areas. And some of those experts discovered that as stakeholders in the administration of justice, there was a need for us to have AGJA in place. And you will agree with me, when you look at the fundamental provisions provided by AGJA, even though it matters on procedure, it has harmonized a lot of things. Some of those information you are talking about That was what gave the government the authority to amend Evidence Act 2011. You remember most of those computer electronic evidence were not in place. Because when you go to court, the defense counsel will raise issues, but when the Evidence Act was amended in 2011, it has solved a lot of problems. And some of those points and some of this electronic evidence you are talking about under Section 84 of the Evidence Act, you will agree with me now, the way you are even mentioning, why don't we have them in police station? You can record statements using your, what do you call your own device, electronic device. They were not there in place before. Now, even the issue of records of arrest, it was a novelty provisions by ACJA. In those days, nothing was there. But now with this ACJA, it has brought a provisions whereby it is a duty to have a central criminal registry records for all arrests made, be it police, be it DSS, be all the law enforcement agencies.